Good morning, and thank you for being here. Today, we are here to inform you of a significant development before the European Court of Human Rights in the case of Socrates versus Portugal. On 26 March 2026, the court decided to communicate the application to the Portuguese government. This is not a routine step. It means that after an initial examination, the court has identified serious legal issues that require a full adversarial review between the parties. This threshold is particularly important. As you know, well over 90% of applications lodged before the court are rejected at a very early stage without any exchange with the respondent state. The fact that this case has been communicated places it within a small category of cases that the court considers sufficiently serious, relevant, and substantiated to warrant detailed judicial scrutiny. It is also important to be precise about what the court has done and what it has not done. First, this is a partial communication. The court has decided to examine a number of core complaints, in particular those relating to, first, the length of the proceedings, which have been going on since 2013. Second, the impact of repeated leaks of confidential information to the media on the applicant's private life. And third, finally, the absence of an effective remedy at the domestic level to address these issues. At the same time, the court has not communicated yet other complaints at this stage, and it has not provided detailed reasoning in that respect. This is consistent with its practice. It also reflects the court's approach to ongoing domestic proceedings, where it intervenes with caution and in line with the principle of subsidiarity. Importantly, the court has not taken any position on the merits of the case yet. What it has done is to clearly identify the issues that, in its view, raise serious questions under the European Conventions of Human Rights. The case will now move to the next phase. The Portuguese government has been invited to submit written observations, and the proceedings will continue in writing before a chamber of the court. From our perspective, this development is a key procedural milestone. It confirms that the case is now firmly within the court's judicial agenda and will be subject to full legal examination at the European level. I will now give the floor to Christophe Marchand, who will explain why this step is not only important in procedural terms, but also raises broader issues about the functioning of criminal justice systems and the protection of fundamental rights in complex and highly mediatized cases. Thank you.
Thank you, Dr. Reber. So we are here today to celebrate somehow an important event. I must say it's very unusual to have such a decision from the European Court of Human Rights within the scope of 9 or 10 months. And so we are very happy about that situation. And we are very happy because it confirms that the work we've been doing on this case since now 2 years is a work that is necessary. It's a work that is really, at this moment, very important, because I think, as we said before, that the decision of this court is very exceptional. So we are used to introduce these kind of procedures before the European Court, and we know that it's very hard to get over this step. And specifically in this case, we had a lot of discussions with the legal team, with Mr. Sócrates and also other lawyers, because it's very unusual to go to the court. And I remember when we had the first press conference, That was the big question. But the case is not finished. Why do you go to the court already? And we said, yes, it's very exceptional within the exception, in the sense that we consider that the violations of the fair trial are so important at this stage that already the right to a fair trial of Mr. Sócrates was infringed, and that there was no reparation possible within the Portuguese system. And that is what is important to me, is that we said that this case represents somehow a model of how a bad prosecution is done by a government, by a judicial system against a political person, because that's the issue. And that's why this case is somehow very political. And so now the European Court has referred the case to the government, asking questions. And these questions are very important because it shows really what we are considering. The first question, as Dr. Heber said, is about the length of the procedure. Why is it lasting so long? Why is it lasting so long? I mean, you can say, okay, this person, former prime minister, from a political party, which is a leftist party, is under prosecution for corruption. Okay, that's very fine. But then you have to come quite quickly with an outcome, with a decision on do you have enough evidence or not? Do you go to court to get this person to face the evidence? You remember what I said a few months ago when we were here, that the general prosecutor of Portugal was saying we have to give the opportunity to Mr. Sócrates to prove his innocence. To prove his innocence. He's presumed guilty or what? What is this kind of declaration? This is really from the highest judicial authority and prosecution authority in a country. This is totally shocking. Of course, there is the presumption of innocence, but he has the chance to prove his innocence. That was really shocking for me. But this is really what it is about. Or you have something and you present it to a court and the person can defend, or you don't have it. And here, the first question is the length of the procedure. And in that frame of that political persecution I was talking about, the so-called lawfare we were talking about, which is the instrumentalization of the judicial to make someone unavailable on the political ground for years and years, because that's the idea of the lawfare. The length of the procedure is very important. Here, I think we can refer to 5 important moments in the procedure. 2013, the beginning of the investigation. 2013, which is 13 years ago. 13 years ago. And still no decision from the court. 2014, Mr. Sócrates was put in jail and was in detention for 11 months. 11 months in detention. 2017, so only 3 or 4 years after, was the formulation of the accusation, which is already something very late, like 4 years after. 2021 was this very important decision. Of course, it's already 8 years after the beginning of the investigation, from the judge who said, okay, we have no charge against Mr. Sócrates on this accusation. We can reformulate the accusation, which then creates a problem about the prescription of the case. And then 2024, which is last year, 2 years ago in January, there was the reformulation, the new accusation. The second time or the third time the new accusation was done. Again, as I said, this length is totally for us. We don't understand why, and the court has the same questions. Then the second issue, the second question by the court, is a violation of the right to privacy, the right to private life, which is framed by the court about the leaks. That's the formulation of the court. Information leaks. So there were leaks that were organized by the prosecution services, by the state organs, by some people in there, by I don't know whom, the police, the prosecution. And the court says this looks like a violation of the right to private life, but also linked to the right to a fair trial. Because of course, when you leak information about a person, and that information is really presented that the person is somehow guilty, then of course you create a context, an atmosphere of which is problematic and which goes precisely in the same direction of this political persecution, which is to put someone out of the political play for a long time, and you let this procedure last so long, and with leaks in order to kill the image of that person, which is what happened in this case. So very important question. And the third question is, of course, okay, it's lasting very long. There has been in parallel a lot of leaks of information. And then third point is, what can a person can do? Is there in the Portugal system a remedy that would help the person who's the victim of this length of the procedure of the violation of the privacy through the leaks to have a remedy, to have a protection from the internal judicial system? And the court is asking Portugal, why doesn't it have any efficient remedy, which is Article 13 of the Convention, to protect his fundamental rights? So this is really, again, a trend in this lawful situation where you are persecuted for a long time, your rights to privacy is violated, you are presented as guilty, and you don't have any internal remedy to get a solution about that. So that's really the three questions that are put now in the garden of the Portuguese government are very, very important. So that's why I think that this is really exceptional, because personally, I've never seen the European Court asking questions to a government in a pending case. In all the cases we've been handling for 30 years, we've never seen that. So it's very exceptional within the exceptional, which really shows for me that this case is really, really exceptional. And then I see it also somehow, because that's how the European Court is functioning. You know, it's about subsidiarity. And that's what Dr. Hebert said, it's subsidiarity, in the sense that now I see it as a conversation between Mr. Sócrates, the court, and the Portuguese state in order to provide a remedy. It's like if the court is showing the path to the judicial authorities in Portugal to be able to stop this persecution, to be able to give to Mr. Sócrates remedies in front of the violation of its fundamental rights, which is now pending before the Portuguese court. Okay, this is everything I had to say. We are at your disposal if you need to have more details and information about this. Thank you.
Okay, just before we go to questions, I will just leave Mr. Sócrates to give some comments in Portuguese, and then we can take some questions.
Obrigado, Marie-Laurent. Minha presença nesta conferência de imprensa tem como principal objetivo de felicitar a minha equipe jurídica, o Christophe, Marie-Laurent, o Martin, pelo excelente trabalho que fizeram e por este extraordinário resultado judicial. Esta decisão do Tribunal é uma decisão a todos os títulos extraordinária, pelas duas razões que os meus advogados já expuseram, não só porque é muito difícil que o Tribunal aceite as queixas, mais de 90% são rejeitadas, mas também porque o Tribunal entende que deve discutir este assunto mesmo durante a pendência do caso nos tribunais portugueses. Para mim é uma grande satisfação ver este resultado, porque pela primeira vez tenho a certeza que o arbítrio destes 13 anos de perseguição judicial será analisado por um tribunal internacional. E se me permitem, eu gostaria de que pudéssemos, por uma vez, separar os factos da opinião. E mostremos os factos cruamente. Primeiro facto. O inquérito criminal durou 4 anos e meio. De julho de 2013 a outubro de 2017. 4 anos e meio. E nesse inquérito não houve nenhuma responsabilidade da defesa. Nenhuma intervenção da defesa. Segundo facto, a instrução durou 3 anos e meio e nenhuma responsabilidade da defesa. Recordo que a instrução decorreu entre outubro de 2017 e abril de 2021. Terceiro ponto. O recurso da decisão instrutória do juiz Ivo Rosa durou 3 anos, de abril de 2021 a janeiro de 2024. E nenhuma responsabilidade nesta demora pode ser atribuída à defesa. Em consequência, se somarmos todos estes prazos, os 4 anos e meio de inquérito, os 3 anos e meio de instrução e os 3 anos de recurso, chegaremos à conclusão que 11 anos de procedimento criminal são da inteira responsabilidade do Estado português. É por isso que toda essa conversa das manobras dilatórias em Portugal é apenas uma patranha, uma artimanha que pretende disfarçar aquilo que é a responsabilidade do Estado e, pelo contrário, tem também a perfídia de querer atribuir essa dilação no tempo à própria defesa. E o que nós estamos a verificar agora é que, depois do Estado ser responsável por 11 anos de perseguição penal, agora quer diminuir os direitos da defesa, dizendo que temos muita pressa e, por isso, nem a escolha do advogado, nem a preparação da defesa está em causa e não pode haver tempo para isso porque temos muita pressa. Não se pode reduzir os direitos da defesa em virtude do Estado ter demorado 11 anos na preparação e no desenvolvimento deste caso. Este é o primeiro ponto. Mas há um segundo ponto do qual vos queria falar. A mãe de todas as manobras dilatórias do processo marquês chama-se lapso de escrita. Foi com esse lapso de escrita, inventado no Tribunal da Relação, digo bem, sublinho, inventado, criado, ficcionado pelo Tribunal da Relação, em 2024, que este processo se arrasta. Este processo foi, em 2021, considerado, primeiro, todas as acusações fantasiosas, sem indícios, e também todas as acusações estavam, ou foram consideradas, todas elas, já prescritas. Em 2024, um Tribunal da Relação muda o crime, muda a acusação, muda a moldura penal e manipula o tempo de prescrição. Foi este o objetivo do lapso de escrita. Não se tratou de nenhum lapso de escrita. Tratou-se, isso sim, de uma golpada judicial. Porque não é permitido, em nenhum regime penal democrático, que 7 anos depois da apresentação de uma acusação, se muda a acusação sem se dar oportunidade de defesa. Eu não tive oportunidade de me defender da nova acusação durante a instrução. Não tive essa oportunidade. Ela foi mudada 7 anos depois de apresentada à primeira. O que é verdadeiramente escandaloso e que viola todas as regras e todos os direitos que as pessoas, os cidadãos têm e que estão protegidos pela Convenção Europeia dos Direitos do Homem. Uma nota final para lembrar que todo o que vejo com clareza, o que é evidente, o que sai deste processo com absoluta clareza, é que a partir de 2021 o sistema judicial organizou-se para perseguir e para derrubar a decisão instrutória do juiz Ivo Rosa. Fez isso com o lapso de escrita, para me levar a julgamento, mas fez pior. Em 2021, a Procuradoria-Geral da República abriu um inquérito ao juiz Ivo Rosa. Perseguiu o juiz Ivo Rosa. Levantou-lhe o segredo bancário, levantou-lhe o segredo, o sigilo fiscal, vigiou a sua vida durante 3 longos anos. O que é absolutamente inacreditável. Num país que pretende ser um país com um sistema penal democrático, a Procuradoria persegue penalmente, judicialmente, com inquéritos que ninguém conhecia, um juiz que tomou uma decisão que não agradou aos procuradores. Isto é de uma gravidade absolutamente inaudita. E lamento muito que o espaço público em Portugal passe por cima disto como se nada fosse. Como se nada existisse. Pois estes foram os 2 pontos que me parecem ser aqueles que mais contribuíram para o arrastar deste processo. O lapso de escrita, o que significa uma nova acusação, feita de forma absolutamente ilegítima, e a perseguição penal ao juiz Ivo Rosa, que afinal de contas tomou apenas uma decisão judicial que não agradou à Procuradoria-Geral da República. Como digo, este é o momento em que nós temos a certeza que um tribunal internacional analisará alguns aspectos deste caso. Para já estes que foram referidos. Mas, mais uma vez, há aspectos, neste caso, de uma gravidade que põe em causa, como digo, aquilo que é a fidelidade de um sistema penal democrático, que o sistema penal democrático deve às garantias constitucionais que são propriedade dos cidadãos e que o sistema não pode e não deve violar. Portanto, para concluir, e mais uma vez, felicitações à Marie-Laurent, ao Christophe e ao Martin pelo vosso trabalho. Pela minha parte, estou muito satisfeito com esta vitória judicial.
Thank you. So we'll now take some questions first.
No. Oui. Just to clarify something, has the court accepted the complaint in full, or does it want just to seek some clarification first?
I think it's just it's an issue about the procedure at the European Court of Human Rights, where you have several phases. You have a first phase, so you send the application, and then within a lapse of 4 to 8 months, the court will take a decision. It will say it's not admissible, and so it will reject 90% of the applications. It's the new policy of the court because there was a lot of criticism because it was very slow, as we know. And so they wanted to now to be fast, and so between 4 and 8 months they say it's admissible or it's not, it's inadmissible, and they reject 90%. In the 10% that is still there, they communicate, they say it's communication to the government. So it's not in the terms you are using. I would be happy to say, yes, the court has accepted the case. It's different, you know, it's the language of the court is very specific. So they communicate the case to the government in 10% of the cases. That's what they did in the case of Mr. Sócrates. They communicate the case to the court. So it means that they analyze the application And then they consider that this is important, that they have to receive answers from the government because the allegations of violation of the fundamental rights are serious. It's not something like they're not going to take it into account. So, but it's only in very 10%, relating to all those criteria they have about admissibility, saying that, oh, is it an important violation? Because if you have a small violation of your fundamental right, the court will dismiss it. They say, no, this is not enough. It's only for important violations of fundamental rights that they will send and communicate with the government. Or they will ask, did you... Yes, it's a first step. It's a first step within the procedure at the European Court. You know, it's a first step that then after that the government has to respond, and you begin like a conversation with the government, because the court is asking. If you go on the internet site of the European Court of Human Rights, it's published today. The questions that are made by the court to the Portuguese government is the case 2407 from 25. You can find easily with that way, and then you will see the questions. So now, of course, it's it's an international court, and so it means that the court is asking questions. They try to make a dialogue with the government. Yes.
I just wanted to understand this. So, after the government answered, the court can decide it. Yes, we'll continue, or it stops.
No, after that, so then we can respond to the court, to the government, to the questions, to the responses from the government. We respond. There is also a phase of negotiation, as we say. It's always like that in international tribunals. You have always a phase of negotiation. It means that sometimes what we have is that in that phase, after the questions, then the government said, okay, I agree, there has been a violation of the convention, okay? And they propose a remedy. In that phase we are entering now. So the Portuguese government could say, I agree, we did a violation and I propose a remedy. And then we discuss whether we accept the remedy and stuff. And if there is no outcome of this negotiation, then it will go to the court. The court will then assess, and will give a decision within 1 year, maybe less. It depends really from one case to another. Here we are in a specific situation where the case is pending, so the court knows it has an influence on the case. And also, there is also this issue whether, there's also a new system within the court. If it's a case where there is like very strong case law, like it's very usual, for example, let's say prison conditions in Belgium. There's a lot of violations against Belgium, so it goes very fast because if it's something new, and here I think we have something quite specific, it can take more than 3 months. It could take maybe 1 year, 2 years before we have a decision. Is that clear for you? Okay, good.
Just to add before, so once a case is communicated by the court to the government, it's exceptionally rare that it will then be considered inadmissible at a further stage, right? So now that it's communicated, yeah, sure, still in its decision later, the court could say it's inadmissible, but it's in really, really rare cases. Yeah, it can happen, but it's really like less than 1% of cases communicated. Okay.
Se não se importa, eu gostaria de fazer um comentário. Eu acho que nós podemos afirmar que o Tribunal Europeu decidiu aceitar, tratar e analisar o caso em contraditório. A partir deste momento, o Tribunal Europeu aceita analisar este caso em particular, dado todas estas questões, considerando a nossa queixa em contraditório. E por isso faz umas perguntas ao Governo, à qual nós responderemos. O caso não está decidido. Claro que não. Mas o Tribunal vai analisá-lo em contraditório. Vai analisá-lo em contraditório. E toda a satisfação que os meus advogados expressam e à qual eu me junto, resulta do facto de aceitar, analisar este caso ser absolutamente extraordinário. É absolutamente extraordinário na generalidade dos casos e é ainda mais extraordinário num caso que está ainda pendente para uma decisão judicial. Há uma decisão a nosso favor? Não, não há. Acho que isso foi absolutamente claro na intervenção dos meus advogados iniciais. Há apenas uma decisão do tribunal de aceitar, analisar em contraditório o caso. E isso é, para quem lida com o Tribunal Europeu, claramente um passo que é da maior importância e que, como já foi dito, é muito raro o Tribunal aceitar tratar, Marie-Laurent fala em 10%, mas se pensarmos nos casos que ainda não têm nenhuma decisão judicial, essa percentagem será ainda menor. É claro que depois, quanto ao julgamento do caso, à decisão sobre o caso, há também percentagens que são indicadas e que vocês poderão consultar em qualquer motor de busca de inteligência artificial. Mas o ponto é este. O Tribunal decidiu aceitar, analisar o caso em contraditório. Isso para nós é motivo de grande satisfação.
Yeah, I think that is important. So the court will examine in either case the submissions from the government, the submissions from Mr. Sócrates, and there will be a decision, except if there's an agreement between the parties before. But there will be a decision. Okay. Yes.
Between the government and the judicial system in Portugal. So why is the government called to answer?
It's the state. It's not the government. Yeah. Yeah.
And now how long is the deadline for the state to answer?
4 months.
And what would you like, what is the remedy that you are envisioning that the Portuguese state offers to Mr.
For me, the only remedy is to stop the prosecution. That's the only remedy that I would see fit for that.
Só para ser um pouco mais específico, julgo, para responder à sua pergunta, acho que foi o Sr. jornalista que perguntou qual é a data para o Estado responder. 23 de julho deste ano, claro.
So, yeah, July 23rd for the government.
Espero que eles não se atrasem desta vez.
Yeah. And then we'll have 6 weeks to answer, to submit our arguments. Another round for the government. Yeah. Other questions? Okay. So I left on the table there our press statement, so you can have like some more precise information. And as Christophe Marchand said, the communication is available on the site, on the court's website, so you can access the questions. Okay. Thank you very much.